You've seen this before, the Canadian Charter of Rights and Freedoms, and here it is here, Section 33, the notwithstanding clause. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Section 7, 215 of this charter. Clear as mud, right? Let me translate. Basically, what this section says is if a provincial government wants to, it can override other sections of the charter, the ones that deal with legal rights, equality rights, and fundamental freedoms. And if a government invokes the clause while bringing down legislation that might violate those rights and freedoms, the legislation can't be challenged in court. There's the big deal. When it was designed, legal experts envisioned the clause only being used in the most extraordinary of circumstances. Think of it as like a break glass in case of emergency clause. But in recent years, it's been used a lot.
And we use the notwithstanding clause to ensure that happened.
For example, Ontario used it to try and end a strike. Quebec used it to prevent court challenges of a ban on public sector workers wearing religious symbols. And remember, 20 years ago, Alberta Premier Ralph Klein used it in an attempt to prevent same-sex marriage. Now, whether those constitute emergencies, so the clause is kind of complicated, and the reasons for invoking it can be too.